Welcome to Law and the Machine, where artificial intelligence meets the legal system, liability, regulation, intellectual property, and the government's uncomfortable role as both rulemaker and AI adopter. The law wasn't written for this. So here's a wild statistic that really puts the brakes on the AI hype train. A recent report found that claims for damages caused by AI systems, whether it's a financial algorithm gone wrong or a medical diagnostic tool making an error, doubled between 2020 and 2022.
Doubled in just 2 years. That's not gradual uptick, that's an explosion. And it's not just the number of claims. The report also highlighted that 60% of businesses are actually hesitant to implement AI at all because they're so worried about who pays when something inevitably goes wrong.
60%? That's a massive chilling effect on innovation. It makes you wonder, if companies are already this scared, how are our legal systems even beginning to grapple with this unprecedented scale of potential harm?
Well, that's precisely the problem. Our traditional legal frameworks were never designed for intelligent machines that learn, evolve, and often operate as complete black boxes. It's creating a profound liability gap.
And that black box problem really is at the heart of it, isn't it? The report calls it out as one of the core challenges to traditional liability. For someone steeped in law and policy, the idea that you can't trace the exact cause of a problem seems like it throws out half the playbook for negligence claims.
It absolutely does. Imagine trying to prove negligence when the system itself can't fully explain why it made a specific decision. These advanced AI models, especially deep learning ones, are built for prediction and pattern recognition, not for generating human-understandable justifications. They take in vast amounts of data, process it through billions of parameters, and spit out an answer. But the path from input to output is often opaque, even to the engineers who built them.
So if an AI misdiagnoses a patient or an autonomous vehicle crashes, you can't just point to a faulty line of code or a specific design choice in the traditional sense. It's not like a car part that snapped.
Exactly. And it gets even more complicated with self-learning systems. They're constantly adapting their behavior based on new data and experiences after they've been deployed. So even if you could understand its initial state, its behavior might have subtly shifted, making it even harder to retrospectively pinpoint causation for a specific error. It's like trying to hit a moving target in the dark.
And on top of that, the report also emphasizes the diffused responsibility. Even if you could understand the AI's internal workings, there are so many hands in the pot when it comes to developing and deploying these systems.
That's right. Think about the entire life cycle. You have the data suppliers who provide the training data, the developers who build the core algorithms, the programmers who write the code, the manufacturers who integrate that AI into a physical product, the deployers, that's the businesses or individuals actually using the AI, and then the end users. If something goes wrong, who's on the hook? Is it the company that supplied biased data, the one that trained the initial model, the manufacturer of the device it's in, or the person operating it who might have used it improperly? The report rightly points out this creates a liability gap where victims might struggle to find anyone accountable.
It's a genuine legal thicket. Our established legal frameworks, like product liability law, were designed for static, tangible products, not evolving, intangible software. But the report suggests product liability might be a key avenue here, even if it needs some serious modernization.
It definitely does. The foundational question is whether AI software actually qualifies as a product under existing statutes. Historically, courts have been divided on that. Some jurisdictions were hesitant to apply product liability principles to standalone software unless it was embedded in a physical product. But the report notes a growing consensus and legislative movement to explicitly include software and AI systems. The European Union, for example, in its new Product Liability Directive, is broadening the definition of product to include software.
That makes sense. If an AI is causing harm, it should be treated with the same seriousness as a physical product. So if we accept software as a product, how would traditional product liability claims typically break down for AI?
Well, product liability generally looks at 3 main avenues for claims. First, you have manufacturing defects. That's when a product departs from its intended design. For AI, this could be a specific coding error, or perhaps an issue with the data used to train a particular instance of an AI model, essentially a flaw in that specific copy of the AI.
So like a batch of faulty physical products, but for software.
Precisely. Then you have design defects. This is when the design itself is flawed, meaning the foreseeable risks of the design outweigh its benefits. For AI, this could be choosing a particular algorithm that's inherently prone to bias, or failing to build in adequate safety features from the ground up. Courts often use a risk utility test here, which, as you can imagine, is incredibly complex when you're talking about the intricacies of an AI system.
And the third avenue?
That's failure to warn or inadequate instructions. Manufacturers have a duty to tell users about the risks of their product and how to use it safely. For AI, that means clearly informing users about the system's limitations, its potential for errors, and the absolute importance of human oversight. The report highlights this as a critical area for AI developers.
Now, a big part of product liability is the concept of strict liability, where a manufacturer can be held responsible even if they weren't negligent. That's a huge lever. What's the debate around applying strict liability to AI?
It's a heated debate. Proponents argue it would force AI developers to prioritize safety, knowing they'd be on the hook regardless of fault, and it would ensure victims have a clear path to compensation. But others caution that imposing strict liability could stifle innovation, especially for smaller developers, by placing an undue burden on them. The EU's revised Product Liability Directive, which the report discusses, is definitely leaning into expanding liability, covering things like damages from faulty software updates and even weak cybersecurity. So, for the EU at least, the trend is towards greater accountability.
When we talk about high stakes, AI and autonomous vehicles and healthcare immediately comes to mind. The report dedicates significant attention to these sectors, and it really drives home how complicated this can get. Let's start with self-driving cars.
Autonomous vehicles are a perfect storm of these liability challenges. When one gets into an accident, you have a whole list of potential culprits. You could have the human driver, because in lower levels of automation, like SAE levels 2 and 3, the human is still expected to monitor and be ready to take over. California law, for instance, still pegs the person in the driver's seat as the operator.
So even if the car is driving itself, you might still be liable. That's a tough pill to swallow for some people.
It is. But then you also have the manufacturer, if the accident was caused by a defect in the vehicle's hardware or the AI software itself, faulty sensors, cameras, or the core algorithms. And separately, the software developer who wrote those algorithms could be responsible. And don't forget the owner, who might have failed to maintain the vehicle or disabled safety features. It's a tangled web. The report points to the UK's Automated and Electric Vehicles Act as an interesting model, where insurers initially cover accidents, but can then seek reimbursement from the manufacturer if a system defect was the cause.
That makes a lot of sense from an insurance perspective, but still means we need clear lines of causation. What about healthcare, where AI is increasingly playing doctor?
In healthcare, the stakes couldn't be higher. AI is being used for everything from diagnostics to robotic surgery. The prevailing view, according to the report, is that the physician remains ultimately responsible for patient care, even when using AI tools. Clinicians are expected to use their professional judgment and not blindly follow AI recommendations.
So if an AI suggests a diagnosis, the doctor still has to verify it.
Exactly. In fact, the report mentions a study with mock jurors finding a radiologist more likely to be found liable for a misdiagnosis if they only reviewed a scan after an AI had flagged it, rather than doing their own initial review as well. This highlights how crucial human oversight and workflow integration are.
That's fascinating. It implies that over-reliance on AI could actually increase a clinician's liability, not reduce it.
Potentially. Now, AI developers could face product liability claims if their diagnostic tools are defective. But there's also the learned intermediary doctrine, which typically shields drug and medical device manufacturers if they've adequately warned the prescribing physician of risks. That could apply here too. But some experts are pushing for shared accountability, where liability is distributed among the clinician, the healthcare institution, and the AI developer. And the report notes that the standard of care in medicine is likely to evolve, meaning not using an effective AI tool could eventually be considered a breach of care. Malpractice insurers are already adapting, adding riders and exclusions for AI.
It's clear that the legal frameworks are struggling, but governments are certainly trying to catch up. The report lays out a fascinating contrast between the European Union and the United States in their approaches to AI regulation.
They really are taking two distinct paths. The EU is leading with a comprehensive risk-based framework. Their approach, as outlined in the report, is all about fundamental rights and safety, ensuring victims of AI harm have the same protection as those harmed by other technologies.
So a broad, all-encompassing strategy?
Precisely. They have the AI Act, which is a landmark regulation that takes a risk-based approach, imposing stricter obligations on high-risk AI systems, things like critical infrastructure, medical devices, law enforcement. While the AI Act focuses on ex-ante compliance, meaning before harm occurs, a breach of its safety standards could directly lead to a finding of defectiveness under their new product liability directive.
So essentially, compliance with the AI Act helps you avoid problems. But if you don't comply and something goes wrong, it makes it easier to sue you.
That's the idea. And then they have the proposed AI liability directive, which aims to provide uniform rules for non-contractual civil liability for AI systems. This is significant because it addresses the black box problem by creating a presumption of causality in certain circumstances, making it easier for victims to establish that link between the AI's fault and their damage.
A presumption of causality. That's a huge shift in the burden of proof, really leveling the playing field for claimants.
It absolutely is. And as we mentioned, the revised Product Liability Directive explicitly includes software and AI, extending liability to things like faulty updates and cybersecurity vulnerabilities. So the EU is building a complete, interconnected legal safety net for AI.
Now, the U.S. approach, as the report details, seems much more fragmented.
It is. In contrast to the EU's top-down approach, the US has so far taken a more fragmented, sector-specific, and state-led approach. There's no unified federal AI liability regime. Instead, AI liability claims primarily fall under existing state-level tort laws, negligence, product liability, and so on.
So, a patchwork of laws across 50 states? That sounds like a regulatory nightmare for companies operating nationally.
It can be. However, the report does note that there's growing momentum for federal action. There's the bipartisan framework for the U.S. AI Act and the proposed AI Lead Act, which aims to establish federal product liability standards for AI and could create a federal cause of action for individuals harmed by AI.
So, a federal push might be on the horizon, but for now, it's mostly states taking the lead.
Exactly. Colorado, for example, passed a law requiring developers of high-risk AI to take reasonable care to prevent algorithmic discrimination. Utah has a law establishing liability for failing to disclose the use of generative AI in certain contexts. So states are creating precedents while the federal government debates a broader strategy.
And speaking of generative AI, the report introduces a whole new frontier of liability, intellectual property. This seems like one of the most contentious areas right now, doesn't it?
It really is. Generative AI models are trained on massive datasets, often scraped from the internet, which inevitably include copyrighted text, images, and code. This has led to a wave of lawsuits from authors, artists, and media companies, all alleging copyright infringement.
So, the core question is whether feeding copyrighted material into an AI for training constitutes fair use.
That's one of the biggest questions courts are grappling with right now. The fair use doctrine allows limited use of copyrighted material for things like criticism, commentary, or research without permission. The argument for AI developers is that the transformative nature of AI training, where the original work is used to create something new, might qualify as fair use. But copyright holders argue it's direct infringement.
And if the AI then produces an output that's substantially similar to a copyrighted work, who's liable? The developer of the AI or the user who prompted it?
That's the other big question. The report notes that in some initial rulings, courts have suggested that the AI developer is the liable party. This is a massive issue. The report highlights a landmark settlement in the Bartz v. Anthropic case in September 2025, where Anthropic reportedly agreed to pay $1.5 billion for using pirated books to train its model.
$1.5 billion. That's an astronomical figure and a huge warning shot across the bow of the entire generative AI industry.
It sent shockwaves for sure, and the report points out that AI-related copyright infringement lawsuits have more than doubled in the past year, with over 70 cases now pending. The outcomes of these cases will fundamentally reshape how generative AI is developed and deployed, likely leading to new licensing models and a greater emphasis on ethically sourced training data.
It all comes back to the question of who pays and who in the value chain is ultimately responsible. The report really emphasizes the complexity of distributing responsibility across that entire AI value chain.
It does. Clearly, the entity that designs, builds, and trains the AI model, the developer or manufacturer, is often seen as the primary party responsible. They're in the best position to identify and mitigate risks. Under product liability law, they're typically the first one you look to.
But the deployer or user also has a significant role, right?
Absolutely. Their liability can stem from negligent use, using the AI for purposes it wasn't intended for, or failing to follow instructions. It could also come from a failure to monitor the AI's performance, not intervening when it makes errors, or even by feeding it biased or inappropriate data to fine-tune it.
So it's not just about what the AI does, but how it's integrated and managed by humans.
Precisely. The legal concept of a reasonable person comes into play here. What would a reasonable developer, deployer, or user have done in similar circumstances? That standard is evolving rapidly as best practices for AI become clearer. And the report mentions vicarious liability, where an employer could be held responsible for harm caused by an AI system they deploy, especially if they didn't provide adequate oversight.
So this isn't just a matter for lawyers and engineers. It's a societal question about how we want to allocate risk and foster innovation responsibly.
That's the crux of it. The report really nails that point in its forward-looking implications. It highlights that as AI becomes more autonomous, what some call agentic AI, executing contracts or making financial transactions, the question of liability becomes even more complex. Traditional agency law will be seriously tested.
Which circles back to the black box problem. The report emphasizes the need for explainable AI, or XAI.
XAI is critical. If we can get AI systems to provide clear, understandable justifications for their decisions, it will go a long way in establishing responsibility and building public trust. Transparency is key.
And the insurance industry clearly has a huge role to play here too.
They do. We're already seeing new insurance products and policy riders specifically for AI-related liabilities. How insurers assess and price these risks will influence how AI is developed and deployed. It's an economic lever for responsible innovation.
And finally, the report touches on international harmonization. Given the different regulatory paths of the EU and US, that feels like a necessity.
Absolutely. A fragmented global landscape will create immense challenges for businesses. International cooperation and harmonization of standards will be essential for legal certainty and fostering responsible AI development worldwide.
This has been an incredibly insightful discussion. It's clear that the question of who pays when AI gets it wrong is not just an academic exercise. It's an urgent, complex challenge that's already impacting innovation and demanding entirely new legal and regulatory approaches.
It's a fundamental question that goes beyond just legal frameworks. It's about how we, as a society, balance the immense potential of AI with the need to protect individuals and ensure justice when harm occurs.
So, if there are a few key takeaways our listeners should really walk away with, what would they be?
First, recognize that AI is already breaking traditional liability frameworks due to the black box problem and diffused responsibility. Second, watch the EU. Their comprehensive, risk-based approach with strict liability and presumptions of causality is a major signal for global trends. Third, the generative AI and intellectual property battle is a new frontier with massive financial implications, as that $1.5 billion settlement shows.
And finally, that the solution isn't just about tweaking old laws. It requires a fundamental rethinking of how we assign responsibility in an era where machines learn and evolve. So as we wrap up, I'm left wondering, as AI systems become truly agentic and make decisions with very little human oversight, will we eventually need to create an entirely new legal entity to hold them accountable, or will the liability always have to trace back to a human actor or corporation?
And on the tech side, what level of explainability are we prepared to demand from AI? And how might that demand fundamentally shift the architectures and capabilities of the AI systems we develop in the future? The law will catch up, eventually.